This is Michael Popok with a Legal AF hot take. I never thought I'd say these words out loud, but Judge Aileen Cannon in the federal court, Southern District of Florida, used the J word out loud in front of Donald Trump while he was in the courtroom. The J standing for jury trial. She's actually talking about a jury trial and the inevitability of a jury trial, including telling Donald Trump in no uncertain terms that a number of his arguments that he's trying to use to dismiss the indictment are not for indictment dismissal purposes. At best, they are for jury instructions. There's that J word again. And they are for defenses, but not for the dismissal of the indictment. That's what Donald Trump's been trying to do at the last minute, a year and a half into the case. Of course, Judge Cannon allowing him to throw the monkey wrenches as late as he has in order to delay the trial. But now we've had the beginnings of a series of hearings that the judge is going to be holding about the 8 or 9 different motions to dismiss the indictment that Donald Trump has brought. Now, this is different. Let me explain it from a trial lawyer, defense lawyer standpoint. You've got a number of ways to represent your client, especially a criminal client. You can move to quash search warrants and the resulting information from that. We're beyond that. This is the Lago case. This was a search warrant authorized by a federal magistrate under Cannon's dominion, if you will, and that's done. All those documents and those 32 separate violations of the Espionage Act are done. So quashing evidence is not in the toolbox for this defendant team. That's gone. Now we move to the indictment. You can move to dismiss the indictment under various grounds. You can say the grand jury was improperly impaneled or heard improper evidence. You can try, as they have, try as you might, to say that the prosecutor is somehow illegal, did illegal conduct, did underhanded conduct, undermined your right to a fair trial. You can file the motions to dismiss saying that certain aspects of the indictment are vague, that elements haven't been met under the law, that the statute you're being prosecuted under is vague. Illegal evidence was used against you and the like. And that's the phase we're in now. And then once you lose that phase and your indictment against you is on solid footing. You know, it may lose a count here or two. We just saw that happen in Georgia. But it is basically the indictment moves forward against you after this motion to dismiss practice. Then you're left, the most you're left with as a defense lawyer is to argue about the instructions given to the jury, about the elements of the law that have been indicted against you, right? And your defenses, and fighting over what defenses you can put in front of the jury. So we're sort of watching all this smush together, but the fact that Judge Cannon actually said out loud at Thursday's hearing this week, the J word, talking about that there is a jury. And how did that come up? Let me explain it. Really, 2 of the motions were up for grabs in this almost full day oral argument or hearing in front of the judge. Jack Smith was there. Didn't do the argument, but Jack Smith was there to support his team. Donald Trump was there, which always makes for weird optics, considering that Judge Cannon is a very young and experienced judge who was appointed by Donald Trump. And so you have that going on, you know, that sort of weather in the room. And then you've got the actual legal arguments and how the judge analyzes it. Right away, the judge shot down very reasonably quickly the argument that the Trump team was making, that the Espionage Act, which has been on the books for decades, right, successfully used in prosecutions by the Department of Justice. It is the number one tool, I would posit, to concerning the improper use of classified documents. It is an Espionage Act charge. That is what Robert Hur, the special counsel, was investigating as to whether the current president of the United States, Joe Biden, committed Espionage Act. That is what a recent, Air National Guardsman, Airman Teixeira, is going to jail for 16 years for violating. You violate, you mishandle classified information, you're staring down the barrel of an Espionage Act claim, and you have for decades. And that's going all the way up to the United States Supreme Court. So for Donald Trump to say, well, when it applies to me as a former president who had some sort of security clearance at the time through the Energy Department, the Q clearance, which is like a tip of the hat to QAnon. The Q clearance. And also I was, Presidential Records Act is in there too, and I was president. And so you put it all together, and it is a vague statute. I can't understand. I can't make heads or tails, Judge, of the plain language of the Espionage Act. Dismiss it. The judge says, oh, well, wait a minute. Terms like unauthorized possession and relating to the national defense, that's not confusing. Get a dictionary. And just because you happen to have been at one time the president of the United States, and you may have had security clearance, and you may have, some sort of Presidential Records Act responsibilities, doesn't make this vague. So she is denied in a very short order, literally. She is denied any attempt to dismiss the Espionage Act count against him. Now, let me just frame it again for you, for those who are kind of joining this story late. There's two basic counts against Donald Trump that drive the indictment. One, the main one, is obstruction of justice. That has to do with the deceptive acts that Donald Trump used in his interactions with his own lawyers, with the Department of Justice, with the presidential records, with the National Archive under the Presidential Records Act, with federal magistrates, with grand jury subpoenas, with, all of that. That deception is the obstruction of justice. When you try to mislead the National Archive, you try to mislead your own lawyers, you instruct them to hide documents, you use your co-conspirators, your maintenance worker, your IT worker, your butler valet to hide boxes in an elaborate shell game, trying to hide it from the government, from the Department of Justice, from your own lawyers, using staff there, including employee number 5, who's now come forward and given testimony to CNN. When you do all that, the count that prosecutors use against you and you get indicted for is obstruction of justice. I've tried so many different things to maintain a heart-healthy lifestyle, like cycling classes and starting a daunting cardio routine. And frankly, it just hasn't been helpful for me. We often think living a more heart-healthy life means making big, unsustainable changes. But with Super Beets Heart Chews, you can get daily blood pressure support in just 2 tasty chews a day. And they even promote heart-healthy energy without the stimulants. Paired with a healthy lifestyle, the antioxidants in Super Beets are clinically shown to be nearly 2 times more effective at promoting normal blood pressure than a healthy lifestyle alone. Heart health is important to me because I want to be around as long as possible for my loved ones and new family. Super Beets Heart Chews give me the peace of mind that I'm doing the right thing and doing something good for myself every day. I take Super Beets Heart Chews every morning, and after taking them, I feel like I have more energy to beat life at its own game. Super Beets Heart Chews are a convenient way to support healthy blood pressure. No pills to swallow, no ingredients to mix or prepare. It's plant-based and no artificial sweeteners or colors. I can't recommend Super Beets Heart Chews enough to our listeners. Double your potential with Super Beets Heart Chews. Get a free month's supply of Super Beets Heart Chews on all bundles and a free full-size bag of turmeric chews valued at $25 with your order by going to legalafbeats.com. Get this exclusive offer only at legalafbeats.com. That's why from day one, Merrick Garland, when he appointed the special counsel, he called this an obstruction case. But it's also an espionage case. And there's at least 32 examples of violation of the Espionage Act in the indictment by Donald Trump. And so the judge said, yeah, I'm not dismissing the long historical legacy of the Espionage Act that's been used successfully in prosecutions and is our number one tool by prosecutors and law enforcement against the improper handling of classified documents just because Donald Trump says so. That was good. But then the J word came up. What she said was, these other arguments that you're making about his mental state, right? Because that's what you deal with in criminal cases, mental state. The mental state of Donald Trump, whether you have mens rea, criminal mind, all of that, okay, that goes to your defense that you put on in front of a jury, the J word, okay? Not, I'm going to dismiss the indictment because of it. And these other things, is what she told them, these other things you're talking about, those go to, like for Espionage Act, you want to get it clear, clarity of thought given to the jury so they properly apply it because you think this statute is vague. We'll do that in jury instructions. There's the J word again. We'll do it in jury instructions. And yet, yes, she hasn't set a jury trial, but she's talking in the language of jury trials. I'm sorry, it's a baby step. It's a small step. Okay, I'm walking. I'm a federal judge. Okay, I'm a federal judge. I'm walking. It's all we can ask for at this point from her, right? These are minor bouts of celebration. That's all we can do. So look, at the end of the day, there's still a lot more for her to decide. There's still a lot more for her to decide as a judge. She only decided these two issues. On the other issue that she also is not buying has to do with whether the Presidential Records Act somehow gives him the ability, Donald Trump, to toss the indictment. And she said, well, that's a defense. That's a defense. Bring it up to the, wait for it, jury. Bring it up. I'm not dismissing your indictment as it relates to it. But the thing that she seems to be very, very concerned about, and she kept kind of dragging the lawyers that were arguing there into this issue, which shows it's like a tell. This is what's on her mind, is the issue of selective or vindictive prosecution. Now, look, Donald Trump has said, oh, they've gone after me for election interference. They're doing the bidding of Joe Biden. It's the Joe Biden-controlled Department of Justice, Merrick Garland, special counsel, all of this. I don't think she's concerned about how the special counsel was appointed or that she's going to throw over the apple cart of decades of independent counsel law to rule that the way that Merrick Garland under the statute appointed the special counsel was improper or illegal, or the way he's getting his budget from Congress and from the Department of Justice is illegal. So forget that. I think that's all noise around the issue. What she wants to get to the bottom of, is there a vindictive or selective prosecution case here? Now look, Robert Hur going after Joe Biden on the same thing, Espionage Act, and improper mishandling of classified documents. Completely different facts, completely different guy, completely different cooperation and self-reporting by Joe Biden of having the boxes. But they went after him, right? Just like they went after the airman who took all of the confidential classified national defense information and decided to share it with his buddies, gaming buddies, on a gaming platform. That guy's going away for 16 years in jail. That just happened 2 weeks ago. So it's very hard for them to argue, we're going after Donald Trump because, selectively. But she's concerned about it. Now, defense lawyers always try this and rarely succeed. But we're going to get to the bottom of it, right? And that's going to come in future hearings and orders. But the takeaway on this hot take, because I got to take them one at a time, is that she used the J word. She said jury trial. She said that's a defense. That's not a grounds to dismiss the claim of the Espionage Act. That's a jury instruction. That's not a dismissal of the indictment. So for whatever reason, she suddenly is getting things right as it relates to the fundamentals that federal judges have to apply as to whether an indictment survives a motion to dismiss. Yeah, we're doing it really late in the game. She should have required these motions be filed 9 months ago, 10 months ago, but she's doing it now. So we're going to have to watch for one more round, which I'll report on here on the MeidasTouch Network and on Legal AF, one more round of motion practice. Then that indictment, in whatever form it's in by that point, Espionage Act still there. Obstruction of justice, likely still there. And if she makes a misstep, just to give people some comfort, like continuing to force the government to put private and confidential witness information on the public docket, that's a no-no. Or rules somehow to dismiss the indictment because of prosecutorial misconduct, which is not present in this case and hasn't even been alleged, or prosecutorial vindictiveness or something, then it's a fast-track appeal to the 11th Circuit, who I'm sure are chomping on the bit to reverse again for the third time Judge Aileen Cannon and get her off the case. So she knows that she is teetering on the precipice of potential removal in the case. Now, she may want to be removed from the case. I don't think she wanted this case, but she certainly has it. And we'll continue to follow everything right here on Legal AF. And I'll do hot takes like this one regularly, every hour if I can, on the MeidasTouch Network and on a show we call Legal AF. Yes, it's cheekily titled, and it means exactly what you think. We do that podcast on Wednesdays and Saturdays, 8 p.m. Eastern time. We pull together the best 4 or 5 stories at the intersection of law, politics, and justice, and we bring them to you right here. So if you like what I'm doing here, you like this kind of content, you want to see more of it, the way to communicate that to the algorithmic gods is to subscribe to this YouTube channel. It's free. That's one. And 2, leave me a comment, right? Thumbs up. Literally, go back, comment, thumbs up. It helps. It's not like ratings on TV. You got to interact with the content in order for you to signal that you want to see more of it. And so until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.